Honorable the Chief Justices and Judges of the High Courts of Andhra Pradesh, Kerala, Punjab and Haryana, Gujarat, Bihar, West Bengal, Honorable Ms. Liz Crone, United Nations Resident Coordinator, and the UNDP representative, Mr. Marcus Brand, Mr. D.K. Sikri, Secretary, Department of Justice, members of the NALSA board, distinguished Chief Justices and judges from abroad, distinguished participants from 21 countries who are here today, Member Secretary of NALSA, Executive Chairpersons and Member Secretaries of the State Legal Services Authorities, representatives of ministries and commissions, international dignitaries, directors of judicial academies, partners of the Department of Justice and UNDP Access to Justice Project, civil society organizations and educational institutions, UNDP participants from India, Asia Pacific Regional Center and other countries, and last but not the least, distinguished friends and members of the media. It's indeed a matter of great privilege for me to be here this morning to participate in this extremely important event, to mark the constitutional imperatives for rendering legal aid to those who can't afford it so that they may access justice in pursuit of their rights. I must compliment the Department of Justice, Government of India and the UNDP for ensuring such an extraordinary attendance on a Saturday morning, which is unheard of in New Delhi. And also, I would like to thank members of the media for being here in the morning. I know that it is very difficult to get media early in the morning for anything in New Delhi. Mr. Sikri, and before him Marcus Brand, dwelt at length on the various initiatives that have been undertaken and which are required to be undertaken to translate into reality the constitutional promise of access to justice for the marginalized. It is therefore difficult for me to elaborate on a very comprehensive exposition on the subject. But allow me to say just this, that as early as 1951, when there was not even a glimmer of the Legal Services Authorities Act, in a celebrated judgment in the case of Jagannath Reddy, the Honorable Supreme Court of India had then stated, as early as 1951, that where a litigant is disabled from accessing justice on account of poverty or otherwise, such a situation would amount to a negation of fair trial. We have thereafter moved, and the famous judgments known as the Golden Troika in Hussain Nara Khatun, thereafter in Khatri's case, and then in Sukhdev's case, the Supreme Court has categorically reiterated and asserted, beyond the pale of ambiguity, that for just, fair and reasonable trial to take place, it is essential for an indigent person or a person who is marginalized by poverty to have access to legal counsel at the expense of the state. It is no longer a matter of largesse by the state. It is indeed a matter of right that inheres in every citizen to have access to quality justice. We have then progressed further down the road of constitutional evolution when the Supreme Court, drawing from Article 21, said that right to fair trial includes the right to a counsel of one's choice as integral component of fair trial, which is a basic structure of the Constitution, and therefore elevated this right to one as a basic structure of the Constitution, as an integral component of the basic structure of the Constitution, inalienable, unamendable, and primordial. Meaning thereby that this right is of the nature which is beyond the transient impulses of elected governments, that this constitutional right is unamendable, even in exercise of parliamentary sovereignty. In a constitutional scheme of governance, we all know that the Constitution prevails. And India is not only a parliamentary democracy, but India is first and foremost a constitutional democracy. And right to justice is a part of the inalienable structure of the Indian Constitution. We then moved further with a view to translating through a statutory instrument this primordial, transcendental constitutional right into a statutory right which would be enforceable both as a part of the constitutional conscience and for the enforcement of which a statutory mechanism has since been put in place. There was then the question of whether this right would remain just on paper or whether it would get translated into action. Obviously, the first issue was creating the requisite human and physical infrastructure for making the promise of Article 39A of the Constitution a reality. We then moved forward again and got as much as $1 billion sanctioned in the cause of free legal aid. It was necessary also for us to ensure that we had the requisite number of trained personnel to offer quality legal aid to those who needed it and who deserved it. We set about the task of enlisting a large number of paralegals, and we then got the Planning Commission of India to have a working paper on the justice delivery system, the first of its kind. And I'm delighted to be able to point out that as a former Minister of State for Parliamentary of Planning, it was my great privilege to see Planning Commission lend its moral, administrative, and political authority behind this extraordinary initiative of the Department of Justice. We have seen that long delays in the justice delivery mechanism, the huge pendency of cases, the proverbial backlog which actually puts an unacceptable pressure on the judicial system, was becoming a challenge. After consulting with all stakeholders, we have now embarked upon a very ambitious project of innovative e-court scheme with an allocation of about $180 million, which would ensure the ICT enablement of all courts in the country. The completion of this project will improve citizen-centric services and will help improve case management system in courts. Additionally, the National Mission for Justice Delivery and Legal Reform has also been announced in 2001 with the objective of reducing pendency and increasing accountability through structural changes and setting performance standards. During this year, a model courts project has been initiated to set up courts of tomorrow that would have the requisite infrastructure and which would be with procedures and processes which would help to deliver expeditious justice. We have all been told that justice delayed is justice denied, and we now therefore have to move on to ensure that justice delivery system is such that unacceptable delays in the delivery of justice are reduced, if not entirely eliminated. The project will witness convergence of several schemes which are interlinked, such as police and prisons reforms, as well as schemes that impact women, children, and other vulnerable groups. A point that Marcus Brand made, that you cannot work in silos. Reform of the legal system must be accompanied by complementing reforms in other sectors. And that is a point which Mr. Marcus Brand is well taken. I'm personally of the view that the entire legal system has to work in tandem in all sectors so that expeditious and quality justice becomes a reality as far as those who are unable to afford it are concerned. The measures which we in India have taken comport fully and are completely in sync with the aspirations of democratic societies throughout the world. The Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights set out specific obligations of the state to provide state-funded counsel for indigent people. The United Nations Principles on Access to Justice and Criminal Justice System, the Africa Commission on Human and People's Rights, the Resolution on the Right to a Fair Trial and Legal Assistance in Africa, and the Lilongwe Declaration on Accessing Legal Aid in the Criminal Justice System are some of the international initiatives that have inspired us and have enabled us to move forward on the necessary path. The Access to Justice project, implemented by the Department of Justice in collaboration with the United Nations Development Programme, is a further example of the efforts being made for creating sustainable and positive change across the states. With a focus on those who are vulnerable and those that live at the periphery of society, the project has made an impact and yielded inspirational results by empowering women and children, scheduled tribes, scheduled castes, and the poor by arming them with information on their rights and by demystifying the justice delivery systems. As we gear up for the next phase of the Access to Justice project, which will be modeled on the experience of the first phase, this conference, I believe, will go a long way in providing further innovative ideas and thoughts. We will hear about the best practices elsewhere in the world in the next 2 days. I'm told that the focus of the next phase of the project will be on acceleration of judicial reforms within the larger framework of making governance more inclusive, accountable, and centralized. This will require greater engagement with legal services authorities and other key delivery institutions. This will also require greater convergence with other ministries and institutions to improve justice delivery for the poor, particularly women. The conference today is in a way an important milestone assigned under the project, and I expect the recommendations and ideas emerging from here will be a valuable input for the next phase of the project. The father of the nation, Mahatma Gandhi, once said, "The first step to achieving justice is to make justice visible, injustice visible," meaning thereby that the pursuit of justice must involve the elimination of injustice. And a necessary ingredient in this endeavor is to make injustice visible so that people collectively react to injustice. And it is unfair, it is unjust for anyone to be denied an opportunity to pursue one's rights according to law for want of impoverishment, for want of economic or other disability. And therefore, as the reverse side of the coin of justice, injustice caused through disability of any kind is to be the focus of our endeavors. And therefore, we need to make concerted efforts, holistic efforts, comprehensive efforts, and sustained efforts to ensure that all that lends to injustice, all that causes the failure of justice, such conditions are eliminated, and in that we will find our true satisfaction. We have come a long way, but I have no doubt, Mr. Sikri, that we have miles to go. I would urge you to ensure that your department regularly monitors the schemes for legal aid on the ground and to redress and address such issues as may be felt or which may arise during the course of the implementation of this very noble and ambitious project. Very often one has noticed that intentions are noble, endeavors are made, but not enough gets translated on the ground. With legal aid for the poor, despite all the progress that you have made, and I would like to compliment you and congratulate you, I believe that we have miles to go before we can sleep. Thank you very much, ladies and gentlemen.